Menendez, the record will reflect.
Robert Gerstein, appearing especially for Erik Menendez, solely with regard to matters of...
Yes, please do.
In March 1994, when Erik appealed to the court to allow Abramson to remain his attorney for the retrial.
I am begging this court to compensate my attorney to represent me. There is no way that I'm going to be able to go to trial without her representation. I don't feel that another attorney, I don't feel I would be able to work with another attorney.
Recently unsealed probate records reveal that most of the money was lost to debts, taxes, legal fees, and overinflated real estate. The family dream house in Calabasas was originally appraised at $2.6 million, but it was sold in September 1994 for half that amount. The $4.8 million mansion in Beverly Hills was sold for less than half its value after standing empty for several years. After the first trials, legal fees for the brothers' defense had reached almost $2 million. According to court records, Erik's lawyer, Leslie Abramson, was paid $650,000, and Lyle's lawyer, Jill Lansing, received about the same amount. Facing retrials, both Menendez brothers declared they are broke. Lyle's attorney, Jill Lansing, asked to be excused for family reasons. Two public defenders have taken over Lyle's case, shifting the expense to taxpayers. Erik pleaded to retain Abramson.
I am begging this court to compensate my attorney to represent me.
My client does not want me to be replaced, nor do I want to be replaced. But I also cannot go bankrupt and provide him with adequate representation.
Judge Cecil Mills denied Abramson's request to be paid $100 an hour, but approved $125,000 annual salary, the amount earned by any experienced public defender handling a death penalty case. Abramson consented.
I'm the cheapest famous lawyer in the entire world at the moment.
Yes.
Thank you. Please state and spell your full name for the record.
Jay J-A-Y-J-A-F-F-E.
Thank you. Mr. Jaffe, what's your occupation?
I'm an attorney at law, licensed practice in the state of California.
And do you have a specialty?
Criminal law.
And are you experienced in defending people
Or,
accused?
excuse me, Ms. Abramson, the court will recognize that Mr. Jaffe is an expert in the area of criminal law, that he's tried many capital cases, that he is qualified to give opinions about the areas that you discussed with Mr. Chalin, and I accept all of those qualifications, and perhaps we can save the time of having to go through them. If you call some witness with whose qualifications I'm not familiar with, I will indicate that to you, and you can go through those.
Thank you very much, Your Honor. Mr. Jaffe, did you represent an individual named Stuart Woodman in a capital murder trial?
Yes,
And how long did you represent Mr. Woodman?
approximately 4 years.
And when you originally became his attorney, were you retained or appointed?
Originally retained.
And at some point, did you seek appointment?
Yes, I did.
Why did you do that?
Sought appointment for two reasons. One, that the original amount in the retainer agreement was insufficient for purposes of the case. We had anticipated that the trial would last approximately 3 to 4 months. We saw that as the case proceeded, it was going to probably last at least a year, which it did. In addition to that, Mr. Chalif and I, Mr. Chalif represents Neil Woodman, I represent Stuart Woodman, had envisioned that the retainer fee would be a certain amount of money. Mr. Woodman's, both Stuart and Neil, were unable to pay the entire fee. As a consequence, we sought appointment from the Superior Court.
And how long had you been representing Mr. Stuart Woodman before you sought appointment from the court?
I began my representation March 11, 1986. I was appointed by the Superior Court in October of 1986.
And this was before there was any trial of the matter?
That's correct.
Had there been a preliminary hearing yet?
There was a preliminary hearing. The preliminary hearing occurred in May of 1986.
And how long did that preliminary hearing last?
I believe 3 weeks to a month.
And from whom did you seek appointment, the municipal court or the Superior Court?
Superior Court, Judge Munoz.
And were you appointed by Judge Munoz?
Yes, it was.
And was that to be paid at $100 an hour?
Yes.
And was any cap or limit placed on your billings?
No.
And did you have to present to Judge Munoz a copy of your retainer agreement before he would appoint you?
No.
Did you in fact even have a written retainer agreement?
I don't recall whether I did or did not. I've looked through my files and have not found one.
And were you asked by Judge Munoz how much you had been paid?
No.
And how much had you been paid, Mr. Jaffe, before you were appointed?
I believe $191,000.
I have nothing further.
I have no questions. You may step down and Mr. Jaffe be excused. Excused with my thanks.
Thank you.
Your Honor, I just want the record to be clear that I don't intend to have every witness I call repeat the assertions in their affidavit, that I'm assuming that the court will accept their affidavit as additional evidence.
Presume you gave them to me because you wanted me to read them, and I had done that.
Thank you, Your Honor. I would next call Roger Diamond.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Please state and spell your full name for the record.
Roger, R-O-G-E-R, John, J-O-N, Diamond, D-I-A-M-O-N-D.
Thank you.
Is the court familiar with Mr. Diamond's qualifications, Your Honor? Thank you. Mr. Diamond, have you, as an experienced criminal defense attorney, had the experience of being retained in a criminal matter and then found it necessary to seek appointment by the court?
Yes.
And would you tell us briefly in what matter that was?
This was a matter in Pasadena involving the Lamb Funeral Home where Jerry and Lorianne Sconce and their son David were originally charged with some felonies involving misuse of corpses, burning bodies, stealing body parts, and so forth. And when I appeared in court for them at the arraignment, the district attorney filed additional charges that were not anticipated at the time, greatly expanding the scope of the case. And although I was originally retained by the family, it became necessary to seek appointment by the court because the preliminary hearing was going to last much longer than initially anticipated.
So you were appointed before preliminary hearing?
I was appointed at the municipal court level, I would say, sometime after the arraignment and before the preliminary hearing actually began, by a judge, Victor Persone, who then was a municipal court judge in Pasadena and who now is a Superior Court judge in Los Angeles County.
And this was not a murder case, is that correct?
This one was not, but later I was to represent him in a murder case.
On this non-murder case, what was the rate of pay that you were granted by the municipal court?
It was either $75 or $100 per hour.
And did you continue as appointed counsel for Mr. Sconce in Superior Court on those charges?
No, and in this particular case in Pasadena, after the preliminary hearing, which lasted 6 months, the Superior Court did not appoint me, not because of anything involving the financial arrangement, but because the district attorney contended that by virtue of my representation of an alleged witness, I would have a conflict of interest, and therefore on that ground alone, the Superior Court did not reappoint me, although the other two attorneys representing the parents were appointed. It was not because of any financial reason that I was not reappointed in the Superior Court.
So
that
perceived conflict of interest?
An alleged conflict of interest that actually did not occur. It was simply a way for the district attorney to keep me off the case at the Superior Court level.
This is relevant.
I know.
See you there. Just try to focus.
I am, Your Honor. Now, did you subsequently appear seeking appointment in Ventura County for Mr. Sconce on a related matter?
Yes, with respect to the case in Pasadena, the new attorney who replaced me pleaded him guilty. He was in prison, and while in prison serving the sentence in the case in Pasadena, the District Attorney of Los Angeles County filed a capital murder charge against David Sconce in the Ventura court pursuant to an agreement with the Ventura District Attorney. The case was actually being prosecuted by Los Angeles County District Attorney. I appeared in Ventura court seeking appointment because Mr. Sconce asked me, by virtue of my relationship with him that I was able to establish during the Pasadena matter, that David Sconce asked the court to appoint me to represent him in the capital murder charge in Ventura County.
And ultimately, after a writ to the Court of Appeal, were you appointed in Ventura County to represent him?
Yes, the Court of Appeal ordered my appointment ordered the court to appoint me, and the court did in compliance with the writ of mandate issued by the Court of Appeal.
And was that under an analysis based on Harris versus Superior Court?
Precisely. I prepared the writ petition in that case. That was the precise basis upon which the appellate court acted.
Thank you, Mr. Diamond. I have nothing further.
Any other questions?
Thank you, Your Honor.
Mr. Diamond, be excused.
Yes, Your Honor.
You may be excused with my thanks. Next witness.
Your Honor, I'd like a brief recess to talk to the next two witnesses if I can, and then I can put them on.
Thank
We'll
you.
be here.
Your Honor, we would call Barry Levin.
Step up here, please, and be placed on the oath, Mr. Levin.
Yes, I do.
Please have a seat. Pull the microphone up right into the face.
Please state and spell your full name for the record.
Barry Levin, L-E-V-I-N.
I take it the court is familiar with Mr. Levin's qualifications. Mr. Levin, have you been privately retained on serious criminal matters over the years?
Yes, I have.
And have you executed written retainer agreements between yourselves and your clients?
Yes, I have.
Are you familiar with the retainer agreement in this case?
Yes.
And based on your expertise and your opinion, does that agreement provide for more than one trial?
No, it does not.
And Mr. Levin, in writing your retainer agreements, do you specifically discuss the issue of retrials or hung juries, or whether the fee covers subsequent trials?
No, I do not.
Are you going to in the future?
Perhaps.
I have nothing further, Your Honor.
Is the word perhaps denote that having heard these exchanges, that you now feel that it might be a better practice to include that?
I'm not so certain of that, Your Honor. I have agreements with my clients. They understand that I'm representing them for the proceeding that they're being prosecuted for. I'm not so certain that it's necessary to discuss retrials, but perhaps it might be the wiser view in the future.
Thank you. Anything further, Ms. Abramson?
I'm approved. Thank you, Mr. Levine.
Will Mr. Levin be excused?
Yes, Mayor.
You are excused at court. Thank you. Next witness.
Peter Giannini, Your Honor.
Mr. Giannini, going to say the same thing?
Well,
Okay. Step up here and be sworn, please.
Please raise your right hand. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, please listen.
Please pull the mic right up and speak into it.
Please state and spell your full name for the record.
My name is Peter Giannini, Giannini.
Mr. Giannini, you specialize in defending people charged with serious crimes,
Yes, I do.
and have you been privately retained by persons accused of serious crimes?
Yes, I have.
And did something occur in the course of your practice that caused you to change the way that you wrote retainer agreements?
Yes.
And do you currently in writing retainer agreements with clients specify what happens in event of a retrial?
I specify that in the event of a retrial, the matter of the fee will have to be renegotiated, and that the retainer agreement, which is for the current trial, is for that trial and that trial only.
And prior to this change, why is it that you now put that in your retainer agreements?
Because I share space with civil lawyers, and they all have it in their retainer agreements, and they convinced me that it would be the better practice, and I had a client raise the issue once.
Okay, prior to that, did your agreement specify that they were only for one trial?
No.
And were they only for one trial?
Absolutely.
And in reading the agreement that was executed between myself and Mr. Menendez, does that read the way your former retainer agreements read?
Essentially.
And does it convey to you an intention to represent through one trial?
Yes.
Nothing further.
Anything further? You may step down. May Mr. Giannini be excused? You are excused, and the court's thanks.
I have one other witness around on these issues, but he's coming from Orange County, and he had called and said he would be late. He's not here yet.
It's certainly accurate. The witness was certainly accurate because the witness is late.
Yes, sir.
We'll go forward.
Okay, well, what we will do is, Mr. Gibson says he's prepared to argue the issue, and when Mr. Early arrives, with the court, we can interrupt him.
You see Mr. Early come into the courtroom, please get my attention, and we'll stop the proceedings at a time that's convenient for the argument and take that testimony.
Thank you.
Christine?
Thank you, Your Honor.
Would it be helpful to your focus if I gave you an indication of my thinking at the moment?
Absolutely, I very much appreciate it, Your Honor.
When we previously were in court on the motion to appoint, which was March 9, the court, based on the declaration of Erik Menendez, the declaration of Leslie Abramson, and the statement in court by Erik Menendez that he did not want his lawyer relieved, made a decision that she would not be relieved. Since that time, and at that hearing, in an inquiry by Ms. Abramson as to why I had relieved Lyle's attorney, And when I pointed out because Lyle's attorney had asked that she be relieved, Ms. Abramson responded that I could certainly provide my client with a declaration that he would sign saying he does not want me to remain on this case because he understands the economic necessity. But I didn't think that was the appropriate way to proceed. And I'm reading from the transcript, page 26211, I think it's volume 156. Subsequent to that time and in support of your motion, the defendant, Erik Menendez, has filed an affidavit saying, to paraphrase it, that he doesn't want her as his lawyer. Well, if she's paid, I guess he feels that she won't give him the same kind of quality of representation if she isn't paid. The issue is different than that was before me. At that point in time, he was telling me under oath he did not want me to relieve her. Now he's telling me under oath that he does. Under the scenario that I have outlined, we need to determine first whether she is to be relieved and then whether she will be reappointed. Based on all that has occurred and the declarations and the documents that you have presented, I am prepared to indicate a willingness to accede to Erik Menendez's desires, because after all, he is the one that has the right to decide whether she is relieved or not. Even if we weren't talking about the money, he would have a right under the cases, and in my view, to discharge her from further service. So, if you wish, I am prepared to rule that she may be relieved for purpose of getting to the second and perhaps more important aspects of the matter. If you prefer to do otherwise, I'll accede to your desires.
Well, Your Honor, we proceeded in the manner suggested by Justice Epstein in People v. Castillo, in which he suggested that counsel there, Mr. Maple, might have resolved the problem there by asking to be relieved unless appointed. We've taken a cue from Justice Epstein and proceeded in that way in order to make it clear that neither defendant nor Ms. Abramson wishes to end the relationship. That's not the purpose here. And we want to make that very clear, and we do not want any gap in representation here. We're very concerned to ensure that defendant has continuous, uninterrupted representation by a single attorney. That was the reason for not proceeding, as Your Honor has suggested, to first ask to be relieved and then appointed. Because, in fact, both defendant and Ms. Abramson very strongly want to continue the relationship provided that she is compensated, though not otherwise. With that proviso, Your Honor, our preference would be not to have her formally relieved as counsel until the question of appointment has been decided by Your Honor. I don't want to stand in the way, however, of going forward if it's just a question of a technicality.
Are we talking semantics on
Yes,
this
Your
issue?
Honor.
I mean, I'm prepared to say...
If that's your view, Your Honor,
I am prepared to say the following, that I would anticipate that I am prepared to relieve Ms. Abramson so that we can address the issue of who should be his counsel. Now, having said that, I am also prepared to allow her to remain as counsel while we address those issues. I also believe that there is present in the courtroom the alternate public defender. At least I had asked them to be present. Is there a representative from the alternate public defender present? Yes, there is. So in the event Ms. Abramson is ultimately relieved, it is likely that there will be nothing greater than a momentary gap in representation. I also have asked the county council and the treasurer tax collector to be present. Are those folks present? Would you state your name loudly, please?
Yes, Your Honor, Joyce Ayala, County Counsel. Mr. George Kosan and Mr. Joe Walker are here from the Treasury.
All right. Now, let me, Ms. Ayala, would you step forward, please? I think that before I can go forward with any aspect of considering appointing anyone, the issue of indigency has to be addressed. Are you in a position at this point, based on prior efforts that have taken place by the treasurer, tax collector, and yourself, to indicate whether or not at this point you believe Erik Menendez to be indigent?
I can indicate to the court that there have been prior efforts in a general search for assets. There have been specific efforts with respect to information given to us from Lyle Menendez when his interview was done on March 9th. We have not done specific asset search for Erik Menendez pending an interview with him where he could provide us that information.
But the information that you had prior to that time would lead you to believe that he is indigent at this time?
The information we have at that time leads us to believe that there are no available assets to him. I don't know what additional information we may be able to uncover after an interview with him.
All right, fine. Then I believe that those comments are adequate to allow us to go forward without interrupting the proceedings, Mr. Gerstein, at this time, to allow them to do those additional studies. At some point during the morning, we may recess for that purpose, but right now I'm prepared to say that if he appears sufficiently indigent that I'm willing to go forward and listen to your arguments, and you may have a seat.
Thank you.
Well, Your Honor, my understanding of the current situation, if I think I've taken Your Honor's point, is that there is no need for me to argue further with regard to the question of Ms. Abramson being relieved as counsel. There's no point in my preaching to the converted, and you have indicated that that is your position, that you are willing to relieve.
That is my position because that is now the position of Mr. Menendez.
Yes, Your Honor. So I take it the question that I should address in argument at this point is the question of appointment.
That's correct.
Thank you, Your Honor. As to that, our position basically then would depend upon Harris and Smith. That is to say, Your Honor, we would argue that Ms. Abramson should be appointed under those decisions of the California Supreme Court because she has a long-standing relationship with defendant. She has already developed a thorough understanding of this matter, and she has, in fact, been representing him continuously in this case from the outset. Given those factors, first of all, with regard to Harris, Harris says that when you have such objective circumstances establishing the special character of a particular attorney's capacity to represent a particular defendant because of their past connection and the attorney's past connection with the case, then it is an abuse of discretion not to appoint. Your Honor, we would say that in this case we have an overwhelming record establishing that. The only consideration on the other side is whether there are countervailing circumstances here. Your Honor, now that Your Honor has dealt with the issue of relief of counsel, quite clearly there are no countervailing circumstances here. Ms. Abramson is the attorney who will be able to try this matter most efficiently and expeditiously. And no one else could possibly come up to speed in this case as quickly. No one else could spend as little time as she will in preparing for this matter, given her past experience in the case. Certainly no one else is likely to be able to establish the kind of relationship of trust and confidence which she has established with this defendant. On those grounds, Your Honor, we'd say that there is absolutely no basis for countervailing circumstances challenging the strong basis of the Harris argument, and that Harris compels appointment here. Further, because unlike Harris, we have here a situation in which the representation, the relationship developed in this very case rather than in a related case. We also have the factor of continuous and uninterrupted representation, particularly in a capital case. And the only way to maintain that here is by the appointment of Ms. Abramson. So once again, on that basis, there is a powerful case for appointment, and there are no countervailing circumstances. This is the most economical way from the point of view of the public to proceed. It is the way that most effectively guarantees Erik Menendez' right to effective assistance of counsel, which the Supreme Court has said implies, wherever possible, the assistance of counsel of choice. In general, Your Honor, I would quote the Supreme Court, much quoted language from People v. Provetti, that the significance of the defendant's right to counsel and to defend himself as he chooses requires the courts to keep to a necessary minimum their interference with the individual's desire to defend himself in whatever manner he deems best. And therefore, that as People v. Ortiz, as the Supreme Court said in People v. Ortiz, we demand of trial courts a resourceful diligence directed toward protection of the right to counsel to the fullest extent consistent with effective judicial administration. Now, in Ortiz, the Supreme Court said that the standard mode of operation, where previously retained counsel has been relieved, is to appoint previously retained counsel, even where no Harris argument has been made, no argument of a particularly strong attorney-client relationship has been shown. Here, we have the standard case of relief of previously retained counsel, which Ortiz says you appoint previously retained counsel, and we have the powerful arguments based on the extraordinarily strong previous relationship and the right to continuous, uninterrupted representation of counsel by a single attorney. So, Your Honor, we contend there's absolutely an overwhelming case for the appointment of Ms. Abramson here.
Are you sure?
Yes, if Your Honor has any questions, I'd be happy to.
I do have, but before I ask them, I wanted to ask if Mr. Ehrman could come in. Apparently not. I would inquire of you in the following area. Your statement that there are no countervailing considerations of significant weight, I believe the case uses comparable weight.
Yes, Your Honor.
Certainly would submit to you that in these times in which we are living, that expenditure of public funds is a countervailing consideration that has to and should be looked at by judges and courts in every action that they take. I believe that some of the other Harris grounds that you raised, such as the relationship, is not quite on all fours with Harris, because it speaks specifically to the fact that those relationships arose in other cases, and the defendants had a great trust in the lawyers because of those cases. This case, the relationship, whatever it is, was developed in this case, and other than the fact that the defendant says he doesn't want to share these things with any other person, really doesn't say to me that he is not capable of cooperating with, or that there is not some other lawyer who could obtain his trust. There's no question that Ms. Abramson is in a position to try this case in a shorter time frame than would any other appointed counsel because of her knowledge of the case. When the motion originally was filed on March 9, Ms. Abramson asked for fees of $100 an hour with the $250,000 cap, and made some comments that she believed that the cap was probably too low. And now you filed your motion and asked for $100 an hour with no cap at all. We're doing business on these capital cases in a different way in this county this time. We're putting them out under contracts. This case, under the flat fee contract, would, in my view, probably be a level 3 case with a fee of $125,000, especially as a retrial.
Mr. Early, sir.
Are you Mr. Early?
Yes, I am.
Well, as soon as I finish my comments, then we'll allow you to take Mr. Early's testimony. If you wish, do you wish him to remain outside? Then, well, as long as I'm running my mouth.
No, Your Honor, I think it's helpful to hear what the court's thinking of.
The,
It's a similar situation.
you have the same view, Mr. Gerson?
Yes, I have no problem with that.
That the cost and expenditures of assigning this case to the alternate public defender would be costs that would accrue in any event. So the only advantage to the public would be that if the alternate public defender assigned to this case were not doing this case, he or she could be doing some other case. But those are costs that the public is going to bear in any event. Any costs that I would impose for appointed counsel would be costs that the public would bear in addition to those costs of the alternate public defender. I have balanced these issues and the costs and against the question of the time that it would take for a new lawyer to become prepared on this case, and I would be prepared to strongly consider, were such an offer made, to authorize this case to be placed under a contract with Ms. Abramson for the $125,000 figure. You want a moment to recess to discuss that with
Well, yes,
Abramson?
we've got Mr. Early, Your Honor, and also I think probably we should take a moment to discuss that.
Before we do that, I would like to know if the court has in hand the declaration of Bruce A. Hoffman, who is the head of alternate public defender, that I believe was prepared for the court's information in this matter. All right. I note that that indicates that it would cost for a grade 4 alternate public defender $125,483.36 for 1 year.
That's correct.
Not total to handle this case.
That's correct.
Let me say that I'm not willing, Your Honor, I can tell you now, to operate under a flat fee contract for reasons that this court is well aware of historically. But I am certainly willing to engage in meaningful discussions with this court as to what would be an appropriate fee for this case with a limit on it, so that the court would be well aware of what the total cost of representation in this case would be.
Well,
I'm certainly willing to discuss the matter with the court, but for reasons that the court's aware of it, I will not sign on to that contract per se. The court is aware of my public opposition to that contract for ethical reasons for many years now.
Well, sure, as I am aware of that. I know that I handed you an application, asked you to make the application, you explained those reasons to me when you declined to do so.
Correct.
But whatever you want to call it, we're talking dollars and cents. I'm not prepared to expose the public to an unlimited expenditure of funds on this case. I'm not prepared to expose the public to an expenditure of funds of $250,000 because I see no reason why, with your knowledge of this case, that the case could not be tried and concluded within a very short period of time. There's no question in my mind that you understand that I feel that you were well compensated for your previous work in this case. And if you have a relationship with your client that you want to preserve, you ought to consider whether you're willing to preserve that by taking some lesser amount of money than would be the optimal in order to accomplish that. And so now, we're just talking dollars and cents and not legal issues.
I'm certainly willing to consider that, Your Honor, and I think Mr. Hersey and I would like to sit down and discuss it. But one of my problems is people who are sitting at the other end of the council table, the court is saying, and I'm quite prepared to take this case back to trial rather expeditiously, but they look more like balls and chains every day, and they get dragged into this case not going back to trial for over a year, and at that point being trial on it. And as this court well knows, I'm sure from this court's experience, the work fills up the time, no matter what you think. And that's my biggest concern. So if we can't take a recess,
that's exactly my concern. If I were to appoint you and set $1 million cap, it would, the work would fill up the time.
But what I mean is, I may be prepared to accept what the alternate public defender would cost, which is $125,000 a year, rather than $125,000 flat.
That means that if it's finished in 6 months, you're willing to take half?
Yes, yes, yes. Because I don't know if it's going to be finished, but even if yes, I may be willing to do that. Let me discuss it with.
Well, let me take a recess, Ms. Abramson, because I would say that you have probably calmed the raging line.
Was that you, sir?
Yeah,
I know.
Because this, and I think that it was clear all along, the dollars was concerning me. There are all these fine legal principles that we talk about, but it comes down to what the exposure should be of the public in this matter. In a case where
we tend to
if you can try a case for the same money with the alternate public defender, which frees them up
to take a different case.
To take another case.
Right.
Then perhaps the public benefits greatly from that. At least they don't get hurt by that, and that's my position. So if you, I'd like to round it off with the figure that I mentioned, because that way that falls in line with my evaluation of where it would be if it was a contract case. I don't care what you call it.
I just want it to be an annual fee, not a flat fee. That's my only concern.
But it will be prorated. If the case should go a month from now, you get 1/12 of that annual fee.
If the case should go a month from now, I would be so happy I'd probably pay the tax.
Why don't we recess before we get off on other tangents, and you can talk to Mr. Early to see whether you want to put this testimony on that?
No, let me just, I might not have to run it. It seems to me we're.
I'm sure we do have your
minutes. I'll ask the folks in the audience to kind of hold the conversation down so they can do their business, and we won't be long. Please let the clerk know as soon as you're ready, and I'll be out.
Thank you.